Go ahead.
Good morning. May it please the court. I'm J.D. Fairchild. I represent Martin Misjuns. And we're hearing an appeal from a motion to dismiss in the lower court. We have submitted transcripts and briefs on this issue. This argument will highlight some of the issues that we hope the court addresses. The first issue is that the lower court did not apply the 12b6 rule to its decision in the motion to dismiss. As we know, that in a motion to dismiss, the facts in the complaint should be taken as true, that reasonable inferences should be in favor of plaintiff, and that the court is to address the issue of whether there can be relief and whether the complaint is pled sufficiently. In the lower court, what ended up happening, and what you'll see, is 7 pages of transcript where the defendant providing alternative facts. And what you may see today is the city providing alternative facts. And in the brief, the city's brief, there are 18 pages of alternative facts. As you read through the transcript of the lower court, you'll find that the judge ultimately adopted the idea of the alternative facts, even going to compare some of the plaintiff's speech with Nazi cartoons from World War II.
Well, what's in dispute here, the posts would seem to speak for themselves.
I agree that the posts should speak for themselves.
Yes, I mean, there's not, you know, it's there for everybody to see what he was saying.
Yes, but in a motion to dismiss standard, the complaint should be tested for its sufficiency. The judge should not have been making a final determination on whether he liked the cartoon or not. And he deviated.
Well, send it back, it's not going to change what this gentleman said.
It is not going to change what this gentleman said,
No,
but
he's stuck with that. You're stuck with that.
And we're okay being stuck with that, but that should not have been a reason to dismiss the case at that point in the 12b6 motions hearing. The court, as you read through the transcript, the judge went so far as to, again, adopt the alternative facts and even deviated from his own opinion written in 2016, Drago versus City of Charlottesville. Judge Moon wrote in that opinion that the government may not prohibit.
How many issues do you have? It struck me as something of a Hail Mary complaint. How many issues do you have? 10?
Judge, we have a total of, I didn't count them out, but close to 10 issues. I have
close to 10 issues. You
yes.
can't count them all. But you don't get to dictate the terms of the case, and you can boil all those 10 issues down, it seems to me, into one issue, that this is a very typical Connick Pickering public employee speech case that ought to be resolved in accordance with the Supreme Court's Connick Pickering balance.
I don't think there would be much of a case at all if our client, Mr. Misjuns, was committing political acts on public time in a firefighter's uniform, or in his personal page, in his personal Facebook page, in his personal life, holding himself as a fire captain and then committing political speech. The issue before the lower court and now before this court is this, that he was on his personal time. He was not claiming to be a fire captain. The Facebook page was his personal page.
Counsel,
the posts were his personal page, and those are protected. That's protected speech.
Quattlebaum has a question for you.
Sorry.
That's right. Yeah. Accepting your position on that, am I correct that the claims against the individuals were initially pled as official capacity claims, and that those have all been dismissed?
Judge, I believe before the court is an amended complaint, and the personal capacity claims were dismissed.
Okay, so what we have is a claims against the municipality, correct?
Yes.
Based on the actions of agents of the municipality?
Yes.
And in that situation, regardless of the merits of the individual claims, doesn't this come down to the Manel test and whether you satisfied that?
The Manel test is going to be part of our argument this morning. My
But,
co-counsel.
I mean, it's critical, right? At least for any of the federal claims. Without Manel, you can't win.
Judge, it is important, yes.
I mean, important's one thing. It is the linchpin. Without it, since you don't have individual claims, that's all there is, right?
Yes,
Okay, thank you.
yes. In determining, but I think what's important is for the court to remember that we were at a motion to dismiss stage, and that the complaint as pled should have been tested on its sufficiency of being pled and the relief that could be granted. And in this case, the facts weren't taken in the plaintiff's favor, and it will be quite easy to remedy the plaintiff's ills through financial or returning him to his job. So it is important that the court understand that we're not at the litigation stage, we're not at trial stage, we're at the motion to dismiss stage, and that standard is very different than what will happen at the jury trial.
Just to follow up, I mean, we have a case, Greensboro, City of Greensboro case that rejected a Manel claim by a firefighter to hold the city liable for the decision of the fire chief. And so I guess there's two ways you can show Manel liability. One would be the actual conduct was made by a final policy decision maker. I don't know how you get past City of Greensboro on that issue. I'd be interested in hearing that. It seems if City of Greensboro is an obstacle to that avenue, it seems like you have to show that you have pled a custom or policy. So could you address that, please?
Judge, I will point out that in our complaint, we did allege Monell, and those facts and the allegations in that, per the 12B6 standard, should have been weighed in our client's favor to move past the motion to dismiss.
But the facts have to be sufficient to plausibly state a claim based on the law. And you can't just say we have a final decision maker if we got City of Goldsboro that says a fire chief, unless you have some way to distinguish that. I don't think 12B6 doesn't, I don't think, let you state a legal conclusion and get past precedent. And maybe you can, so I'm trying to invite you to tell me if your argument on Manel is that you have a final decision maker. It seems to me City of Greensboro is a big problem for you. If I'm wrong, please explain why.
One of the issues in this case is that there was complaints made by a group called Hill City Pride, and they called into the mayor, and the city manager and the fire chief all had conversations. We even filed a conspiracy claim in the complaint addressing some of the issues between these decision makers acting in accordance when they terminated.
Yeah, but you alleged in your complaint that his boss in the fire department was the decision maker. You didn't reference the mayor, you didn't reference the vice mayor. I mean, you have facts about those, but you can't say this person's our decision maker and now come in here, I don't think, and say, well, someone else was the decision maker.
Judge, our complaint did lay out facts about the conversations between those people.
Sure.
But I will have to concede that the notice of intent to dismiss was delivered by the fire chief.
Well, it's not
But
just
that
that's
doesn't-
what happened factually. When you alleged a claim, you said that was the final decision maker. You didn't say either he or the mayor or the vice mayor or someone else. I mean, I'm not fussing at you. That may be fair. I'm just saying, if that's the case, how do we deal with Greensboro?
I would say that I think, of course, we're in this courtroom, but we're parsing words. The fire chief being the final decision maker is, in the complaint, the gentleman who delivered the final letter, the notice of intent to dismiss to our client.
All right,
That doesn't
thank you,
exclude
counsel.
what happened prior to that.
You have some rebuttal time.
So, all right.
Thank you.
Thank you.
All right. Counsel, I'm having a hard time figuring out what exactly the city did wrong here, because you have an individual, and you might think he's protesting as an individual, but it's hard for him to shake his association with the city. And the particular speech here is about as raw as it gets, and that's not a problem for private individual. People can say outrageous things, but it's very hard for him to shake his association and position with the city's fire department. And if I were a city official, I would be very concerned about the relationship that the fire department had with the citizens of the city of Lynchburg. And you're talking about speech. What your client is doing is chilling the speech of other people. Because let's suppose someone has a Black Lives Matter, a poster in their front lawn. There are many of them in Charlottesville.
Yes, sir.
And when they see a post like this, they're gonna wonder if the fire department is gonna treat their homes fairly. If a fire breaks out. And the same is true. The city has to be concerned about its ability to recruit firefighters who are of a minority race, and they're gonna look at this and say, this is not a hospitable environment for me, and I'm not gonna sign up for something where somebody is, a high official in the department is spewing this kind of racism. And so this individual is sowing mistrust on the part of citizens who depend upon the fire department to treat their homes fairly, and it is constricting the ability of the city to attract able candidates and applicants from all of its citizens. And so I'm having trouble figuring out what in the world the city did here that was wrong in trying to resolve those problems.
Sure. Thank you, Your Honor. First off, I would say, as we talked about a little bit in our brief, the heckler's veto. I think that it is a very dangerous position if somebody is a Trump supporter than to suggest that they can't.
Are you going to answer my questions?
Yes, sir. I
It
assume
seemed
that.
to me you were going off on some toot of your own. Answer my questions.
Yes, sir. I assume what the court is talking about is the Black Lives Matter post that Mr. Misjuns made, or statement that he made. In that case, he was talking about the individuals who killed David Dorn, the St. Louis fire captain, who was an African-American retired officer who was killed by looters. Mr. Misjuns made the statement that we have looters, we have hooligans posing as Black Lives Matter protester who took the life of this African-American gentleman. So I think if the city is reading that as a racist statement, I think the city has simply got its facts wrong. With regard to the transgender comments, again, I think we're on somewhat dangerous ground if, I mean, we're in a very polarized world right now, Your Honor. We're being in favor of President Trump and some quarters.
The First Amendment protects the speech per se. You can say totally vile things, and we would protect it because we don't want viewpoint discrimination. But there's a separate line of cases, and the problem was, from the First Amendment standpoint, was not what he said, however odious it was, and it was unbelievably odious, but the position from which he said it. He's not just a private citizen. He is a public employee. He holds a responsible position in the firefighting bureaucracy. And what he said is going to be received by the citizens of Lynchburg as something that the fire department was willing to tolerate. And you're saying a municipality cannot take steps to resolve those problems?
Again, Judge, as Your Honor pointed out, we're talking about the Pickering-Connick line of cases. I would argue that to make that determination at the 12B6 motion to dismiss stage, Judge, would just be improper. I think that goes to the merits of his statements. And I think that should have been left for perhaps a Rule 56 summary judgment question. I think that really is a decision on the merits. Did his statements cross the line? Was there a Pickering-Connick issue? I think that really is a merits question, Judge, and not a 12B6 question. If I could address Judge Quattlebaum's question very quickly in my remaining time on Monell, I think the judge is right. Monell is the linchpin of our case. Judge, how we get past the Goldsboro decision is that the employee handbook for Lynchburg City specifically says, and Chief Wormser's notice of intent to dismiss, which was attached with the complaint, he wrote, "I am intending to terminate your employment in accordance with the procedures set forth in Chapter 7, Section 6, subsection M5 of the Personnel Manual." That section states in relevant part, the director considers the response and makes a final determination to dismiss. So in Lynchburg, department directors do have final authority on behalf of the city to make termination decisions. Not just the fire chief, but any department director.
But in order for municipal liability to attach, the municipality has to have done something wrong. They have to violate a federal right or a constitutional right. And the kind of Pickering balance indicates that if they have a legitimate and significant state interest, they can act on that. And there's been no violation of a federal right or a constitutional right under the Connick-Pickering balance. And therefore, municipal liability does not follow.
Sure.
And we can talk about policymakers and the rest, and that's fine, but there has to be some violation or infraction before liability can attach to anyone.
Yes, sir, and Judge, I see my time has expired. May I briefly respond?
Well, why don't you wait for the rebuttal, okay? Unless
Yes,
my
sir.
colleagues have some questions. Roger. We don't have any questions.
Thank you, Your Honors.
Okay. Ms. Royer?
May it please the court. Good morning. My name is Jennifer Royer, and I'm here on behalf of the city of Lynchburg. And very briefly, before we get into the substance of the underlying questions of the court, I would like to address the allegations that the district court viewed this from the wrong standard. The allegation is that the city put forward alternative facts and that the district court adopted those facts. However, if you look at the memorandum opinion statement of facts very closely tracks those that were set forth in the amended complaint. The allegations that the city made with respect to its reasoning for its decisions are not actually identified in the court's memorandum opinion. So the correct standard was applied, and that really is a non-issue before the court. Now, I'd like to discuss Judge Quattlebaum's concerns with regards to Monell, because frankly, without Monell, there is no case. And when we look at Monell, it's really important to note that the city has to have done its own unconstitutional act. It is not sufficient for someone to allege that an employee has created an unconstitutional act for which the city ought to be liable. And there are a couple of ways, 4 ways exactly, that the plaintiff could have asserted facts to establish a Monell claim. The first, of course, being that there would be an express policy stated in a regulation or an ordinance. Then, of course, there is the final decision-making authority. Third, there is an omission that evinces a deliberate indifference to the rights of the citizens. And fourth, being that of a customer policy. Now, the facts on the complaint simply do not establish a Monell claim against the city of Lynchburg. Looking at the person with final policy-making authority, honestly, it's an open question based on the amended complaint who the plaintiff thought was the final policy-making authority. At various points, he asserts that he was terminated by the fire chief, and then he says he was terminated by the fire chief at the direction of the individual defendants. However, looking at the case that we were discussing earlier, the Goldsboro case, the fire chief is not a person with final policy-making authority on behalf of the city. So there would have had to have been other allegations actually identifying who that final policy-making authority was. And they simply don't do that in this case. In terms of the,
'Cause I find it hard to believe that, that any municipality would have taken any other action. I mean, they did what any municipality would do. And you can't have a municipal government, which is, the high officials are broadly distrusted within the citizens who are the subject of that government. And you can't project a hostility to people who might want to become firefighters and are reluctant to take that step because the firefighter, the whole department has tolerated this person right in its midst. And any municipality would do what this municipality would do to clean up its act and communicate a simple message to the citizens of Lynchburg, and that is that this fire department is open to everyone. And it will fight fires without respect to anyone's political point of view. And I come back to the thing where somebody has a sign of Black Lives Matter in their lawn. They're perfectly free to do that in our country. And they would have questions, given this man's hostility, as to whether those firefighters are going to pass them by if they have a problem in their home. And that is an appalling situation. And the post here is about as raw and virulent as you can get, and that's fine for a private citizen. If they want to spew that stuff, it's okay, but it is not fine for somebody in his position to have said what he said.
I do not disagree with you, Your Honor. And in fact, what the city did was on all fours with this court's precedent in the Gretzmacher case out of Howard County. In the Gretzmacher case, there were a series of elements, for lack of a better word, that a municipal government can look at in determining whether or not an employee's speech passes muster and whether or not the efficiency of the government is impacted and impaired by that speech. And to be sure, when you look at the notice of the complaint that was given to, the complaints from the citizens that was given to Mr. Misjuns pursuant to his firefighter Bill of Rights, and you look at the notice of intent to terminate, those documents both being a part of the record before this court and being a part of the record before the district court as well, the biggest concern here is that citizens are coming forward saying, I have concerns that if I or my family member need assistance, that and Mr. Misjuns is called upon to arrive to my residence, he will not give us the care to which we are entitled. Specifically, when you think about it, Mr. Misjuns was a fire captain in the department, but he was also a paramedic. And a lot of departments don't necessarily have firefighters and paramedics in the same role, but he was in both roles. And I want to kind of turn this in terms of these individuals' thought process that when you call for a paramedic, you are calling when you are in your most vulnerable state. You are in need of life-saving measures for you or your family members. And if Mr. Misjuns, having publicly posted his views on individuals who are transgender, arrives to your residence and you are in fact transgender and your outward appearance does not match your biological makeup when they take off your clothes, are there going to be critical seconds lost in rendering care? And that was the concern that was expressed to city officials time and time again by these citizen complainants. And of course, that is a huge concern for the city in terms of its obligation.
So counsel, I want to make sure I understand your argument. I understand that point, and that may be sufficient on the merits to say this isn't a violation. And it may be 100% right, but it sounds in making that, I wonder if you're not essentially saying there is this is part of a policy that the city has, that it's not just a decision as to this individual. There is a policy that the city has that if concerns are legitimately or maybe not, maybe whether legitimate or not raised, we don't, we're going to take action. And I'm not saying that's wrong to do that, but I'm wondering if that makes us have to decide the merits of it, which you may want us to do, or whether you're, but it seems like in doing that, you're walking into prong 4 of Manel, as I hear you talking.
So let me answer that point, because I do think that the argument that I made was more towards the merits, because I think it's apparent why the city did what it did. However, in terms of the pleading itself on a 12b6 standard, looking at the allegations of fact for the purposes of a Monell claim, the city is going to, just like any good corporate steward would, investigate any complaints made by anyone against an employee. And that is, if somebody came to my office and they complained about one of my staff members, I'm going to look into that. And it's not necessarily a policy to do so, although there are personnel manuals that say that,
This policy or custom, right?
So the custom, yes. So we have the express policy, and we also have policy or custom. But when we look at policy and custom, we have to look at whether or not the allegations show that the city had a policy or custom, not of investigating complaints against their employees, but whether or not they had a policy or custom of unconstitutional action. And when we look at what constitutes policy or custom, sometimes we look at it in terms of, is there a pattern here where you have an instance where the city has violated someone's rights under the Constitution, under the Fourth Amendment, under the First Amendment in this case. There have been no allegations on the face of this complaint that established that there was a policy or custom of the city to violate an employee's constitutional rights to speech. That's what he would have to show, and he would have to show that not just in his own instance, saying that they violated my rights to First Amendment protections.
Why don't the allegations that he made, I think in the complaint, that, that we have zero tolerance, for example, for this type of speech, this type of conduct.
Okay.
At a 12b6 stage, is it reasonable for us to infer that that means this type of stuff is, out of bounds, and you can argue it's not a First Amendment violation, and maybe you went on that, but why does that at least not let us infer that that's something that the city does on a more systematic basis?
I would ask you to look at the content of that email in which it was asserted. So that was an email from Mary Jane Dolan to the interim city manager, Dr. Reed Wodeka, in which she expresses her opinion that the city ought not have speech that is harassing or disparaging to citizens. And that is her expressing her own First Amendment protected rights to express her grievances to her city elected representatives. She was not talking in any kind of official capacity in that instance, because frankly, as a city manager managed form of government, the mayor does not have any ability to extract discipline or to enact discipline against employees. So she, in that email, in that instance, is expressing her personally held belief that the city ought not have ought to have a zero tolerance policy for employees engaging in hostile speech towards citizens.
So your view is that's her personal review, not reflective of a city policy?
That is absolutely correct, because, and again, elected officials, they don't lose their First Amendment protections when they take the dais. She did not have any authority of her own to do anything with respect to any disciplinary issues, any investigative issues, because of the type of government that the city of Lynchburg is. So she was expressing to someone who might be in that position to say, hey, we ought to have a zero tolerance policy for speech that discriminates against our citizens. And that is her protected First Amendment right. It is not, in fact, a policy or custom of the city.
Although I suppose you can make the point that if there is a policy, the policy is a good one. And I'm not sure that the record here presents situations where the city had acted inconsistently with what they did in this instance. And so what they did in this instance, if it's reflective of anything, it's reflective of a good policy. And the policy that it was reflected at, there is no evidence that it was applied in a haphazard way. Now, they bring up the question of the fire chief or somebody attending the BLM rally, but that is not a similarly situated individual. That is whether it's advisable or inadvisable, it's a totally benign action compared to what was done here.
So, Your Honor, if I may, because I think you are veering into their equal protection claim, and I just want to close the chapter on the Monell claim and the policy violation, or the express policy that's whether or not they asserted an express policy that was violative of his constitutional rights. It is, whether it's a good policy or otherwise a bad policy really isn't the question. The question is whether or not they have an express policy or a policy or custom that violates someone's rights. And here, there was no allegation that any express policy or any policy or custom violated Mr. Misjuns' rights. No factual support for that. Now, Your Honor, moving into the equal protection analysis, there is a claim for the 14th Amendment here.
Well, the equal protection claims are when you treating similarly situated individuals in a dissimilar manner.
Correct.
And these are not, this example is not of a similarly situated individual.
As a practical matter, no, Your Honor, it is not. But specifically to the complaint, there are no allegations of fact on the face of the complaint that would show how they are similarly situated. And that is a pleading requirement on an equal protection claim. So the city is not required to treat dissimilar people the same. It's not. And in order to establish...
We understand that, and it's in your brief. At this point, I think it would be productive if I ask my friend Judge Gregory if he had any questions, or do you have any further questions? All right, thank you. We have no further questions.
Okay, Your Honor, I just wanted to ask before I sat down, is there any particular argument that you wanted to have any more information on?
If there were, we would have had questions.
Thank you, Your Honor. I will stand on my brief and ask that the court affirm the decision of the city, or the district court dismissing the complaint. Thank you.
Thank you. Mr. Fairchild?
Judge, just very briefly, I appreciate your passion for protecting minorities, but I think it's important when you're governing a city and you're managing city employees that we're protecting minorities and we're also protecting what might be considered mainstream or a different type of minority. And I think what the city is getting wrong here is moving to protect one side to the exclusion of another side. Further, I think we are still at a 12B6 standard, and I want to leave that strong with the court to consider. And I want to point out that there is no
what you said is just not true, because you can't point to an instance of where a minority office holder in the fire department was spewing racist comments against whites, and there's no indication that the city would tolerate that. And so the city is not, there's no showing here that the city is protecting one group as opposed to another, because you don't have a minority office holder in the fire department spewing that kind of rhetoric.
Judge, it could be argued that the chief of the fire department is a minority, and he terminated a white firefighter for speech that he did not like, that was not in uniform, not on the company dime, and not representing the fire department. So I can only litigate the cases that I'm retained for, and so I don't have an example for you of a minority that I would represent. But I am in this case, And I'm running out of time, so I will leave you with that.
Thank you. Mr. Boyer?
Thank you, Your Honor. I would say we actually do have an example in Lynchburg, which came out in discovery, but was not in the complaint, because we learned about it in discovery, of a minority firefighter who was spewing racial hatred, and the city did not discipline him until after this litigation began, and the city felt its hand was forced. But we didn't learn about that until discovery, so that was not anything we could have pleaded in the complaint. I would argue, Judge, again, I want to make sure the court is clear that Mr. Misjuns was not saying anything critical of BLM. He was saying something critical of hoodlums taking advantage of the BLM protests to kill and loot, to kill a black retired firefighter and loot the store that he was being retained as a security guard for, that he was abusing the BLM movement, Your Honor, was Mr. Misjuns' entire point. But with regard to the court's concern about the city not being open to anyone, I think the firing of Mr. Misjuns is a very telling statement that the city is not open to everybody. If you believe that, and are willing to state publicly that bathrooms ought to be segregated by biological sex, that's what really triggered this, Judge. That was the opening salvo, if you will. If you believe that, you're at risk of losing your job in the city of Lynchburg. So I think there's a chilling effect by the city, and I think the city is clearly saying we're not open to everybody. With regard to Judge Quattlebaum's point, yes, Mr. Dolan's statement, or Mayor Dolan's statement that the city should have a zero tolerance policy. The city needs to take action against this, and then Chief Wormser does what the mayor wanted him to do and fires Mr. Misjuns. As opposing counsel pointed out, the mayor has no authority to fire. Under the city's policy handbook, it is the fire chief, it is the department chiefs who have the final authority to fire and make those disciplinary decisions on behalf of the city. It can be reviewed by the city manager, but it was not reversed by the city manager. So we did plead that there was a final decision maker, and we should win on Monell. This court should, again, recalling this as a 12B6 motion, this court should reverse. Thank you, Your Honors.
Thank you, counsel. We will come down and greet counsel, and then we will proceed directly into our next case. All right, and Garten Trucking versus NLRB, and Mr. Tower, we're happy to hear from you, sir. Please.
Thank you, Your Honors. May it please the court. My name is King Tower. I'm with Woods Rogers in Roanoke, and I'm here today on behalf of Garten Trucking in this case of Garten Trucking versus the National Labor Relations Board. Your Honors, I know you've reviewed our briefs, and so I'll be brief in terms of the facts, but there really aren't too many facts, and there really is very little dispute about what took place here. Garten Trucking is in the transportation business. They move paper and other products in Covington, Virginia. And in 2001, there was a union campaign where the Association of Western Pulp and Paper Workers filed a petition to organize the drivers at Garten Trucking. It was a unit of about 109 workers. And a vote was held, and the employees voted overwhelmingly against union representation. About, actually a little more than a year later, after the election, although the exceptions were still being litigated, they still are, the union distributed a flyer to employees. And this flyer made several points. It implied that the union was responsible for wage increases that had taken place recently. It falsely accused the company of picking and choosing who would get raises.
Counsel, I don't mean to cut you off, but we've read
got this.
some of that, and you're welcome to weave that in, but if you don't mind, I'm gonna get to, a legal principle. I know you're familiar with it. I'm asking you how we handle that with respect, handle this issue with respect to your position. We have case law that seems to pretty clearly say that we are to defer to the board in terms of whether conduct is coercive. So what do we do with that? I mean, the board determines this is coercive. This last sentence of the statement does, it seems to me, could be read to say that the union is responsible for some failure to get raises. That may not make a lot of sense when the election, the vote has happened and when the raises have been given. I mean, I get that, but I mean, if we're supposed to defer and it could be read that way, what do we do with our precedent?
Thank you, Your Honor. I think the answer to that is that the deference that this court should show is not total, and that the board's decision has to be supported by substantial evidence in the record. And I think that, as in the Allentown Mac case, for example, the board is not free to draw whatever inferences it wants
But
from.
isn't the statement evidence in the record?
It is in the record.
So that counts as evidence. Now, you may argue it's unreasonable to interpret that as coercive. That's what you got to say, right? I mean, that could not be interpreted reasonably in that way?
And what we're saying is that even applying an objective standard, as the board seems to focus on, we're not suggesting that you need to subjectively look at the understanding of employees. What we're saying is that the standard is in the totality of the circumstances, and that includes the context for the statement. Was the statement coercive or was it a threat? And our position is that it is not when you take those circumstances into account. So it is still an objective test that we're proposing. We're not suggesting.
But do you agree with me that you not only have to convince us that your reading is better, that it's a better reading to say it's not coercive, you have to say it's totally unreasonable to be read otherwise?
Well, I think we are saying that when you look at the totality of the circumstances, that the board has taken a position that is not supported by that totality of the evidence. And so that, particularly again, in light of Mr. Garten's statement being in response to this flyer that the union distributed, and clearly the primary thrust of it being that the union was not responsible for these raises, and the fact that raises were not delayed, as you mentioned. In fact, the only evidence on that subject is that the raises were actually given in advance of the time that they would otherwise have been scheduled.
Did the Chevron case alter the substantial evidence standard of review?
Well, Your Honor, our view is that the Section 8C of the Act allows employers to engage in speech so long as it is not a threat or a promise. And so I don't know that there's any ambiguity. There's an interpretation.
Right, but I mean, the substantial evidence standard of review, it seemed to me that the Chevron case was directed at more at the regulatory function of agencies and the interpretation of statutes in the course of the rulemaking process. But I think that the adjudicatory function of agencies was, it's harder to make the case that overturning Chevron affects the adjudicatory function to the same degree that it affected the regulatory function. And if that's the case, then aren't my colleague's comments, Judge Quattlebaum's comments, don't they become especially pertinent in terms of the standard of review that we owe to the agency in the NLRB in this case?
I think that's right, Your Honor, that you could decide that the Loper-Bright decision and the overturning of Chevron were relevant to even the adjudicatory function. But if you do not, our case is not premised on that. Our case is that even under the traditional substantial support of evidence in the record, that the board has committed error here and that it should be set aside.
Just a curiosity, but how did part of the thing is that this statement was in response to some statements that the union was making. And the union was making these statements and putting out these pamphlets or whatever at the same time the matter's being litigated. So that seemed to me odd that while the matter was pending before the board, that the union was continuing to fire up. But the election was already held, wasn't it?
More than a year prior, Your Honor.
So why is this stuff going on long after the election has been held?
Well, and I think, Your Honor, that's a great question, and it sort of speaks to the reaction that it prompted from the company and the hyperbole that followed. And there's definitely some over-the-top type statements that are not really part of this, other than they show the context of a company official reacting to, why is it that a year after we've had this election, the union are coming in and acting like we should have been negotiating with you.
The timing of the union's comments and the response, the coerciveness inquiry wouldn't necessarily be altered because this was an individual that was a part owner of the company and he had authority to comment on past wages and the likelihood of future raises. And so the statement, even though it was after the completion of the election, the statement could still be held coercive, could it not? Because it conveyed the message that in the future you better keep this union at bay or you're not going to get your raise.
I think you're right, Your Honor, that the fact that it was this far after the election does not, on some sort of per se basis, mean that it couldn't possibly be a threat. And a manager like this, an owner, could absolutely.
All I'm saying is there's no bar to post-election statements being coercive.
That's right, that's right. And so if this statement is a threat, it could violate 8A1. And I think that.
So what's kind of odd is to follow up on Judge Wilkinson's questions, is the union, well, the elections has happened, raises have been given. The union statement seems to be commenting about those raises that have been given. They're claiming credit for it.
Right.
And the responsive statement responds to that for 7.5 lines. And I don't think there's any question no challenge to that. But in the last 1.5 line, the response is kind of nonsensical. I mean, well, there's two ways to look at it, it seems to me, and this maybe tell me what your reaction is. On the one hand, it's nonsensical because it's saying, you would have already got your raises if they haven't been getting money, stealing from your paycheck. Well, if they've already gotten their raises, that kind of doesn't make any sense. But could it also be read to say, I have an input in whether you're gonna get raises in the future? And could someone read it to say, there's still raises to be considered in the future, and this union activity is going to, be an impediment to those?
Right.
So, you see what I'm saying?
I do,
mean,
I understand, Your Honor, and I think that is, the general counsel is making that argument, and I think that they are arguing that that is an implication of the final line of that statement. But I think our point is that the board has otherwise acted like all they have to do is put this statement in the record, and the mere utterance itself
Right.
creates this basically a presumption of a threat. And what we're saying is that that's not the standard. The standard should be taking the totality of the circumstances. Is there a threat that has been communicated? And that involves both the distribution to employees. Here, the evidence is there were only 7 employees who reacted to this post, all positively or at least neutrally. No person testified that I felt threatened.
So what does that have to do with anything? I mean, I understand why in a normal world we might think that is evidence, but can we even consider that evidence? There's case law that says, employees are in a position of, lesser power, so you can't consider that? Or is it your position that we can consider it?
Well, our position is not that their subjective response is dispositive, but we do think that it shows that a reasonable person would not find it threatening in the context of all the facts and the totality of these circumstances, including the ones you mentioned, which is that the statement is sort of nonsensical and hyperbolic in the first place.
But your problem, though, is silence hurts you. In a sense, the more effective it is, the more silence.
It could be, Your Honor, and that's, I understand that assertion, and so, there is a distribution issue, I think. If an employer walks out into the parking lot and says, I promise you 100% wage increases, but there's nobody around, have they committed an 8A1 violation? And I think, so there's got to be some evidence that there was a communication here. But even if you deem that
Well, there's definitely communication. It's on the company site. So,
Yeah.
I mean, there's no question that it's out there for all the employees to see. So what's another thing I'm sorry, Judge Gregory.
No, I didn't. Go ahead.
Another thing that seems weird about this case to me is, there's this other litigation that seems to be the big, more important matter about whether or not there was improprieties in the union election. And I guess they were found to have existed. And it's just odd to me, we got that big, important issue, and this seems to be kind of I don't mean to belittle the importance of it, because threatening, maybe that's just the facts procedural where we are, but this is about whether you post something in a room somewhere. It seems kind of, is there some story that I'm not understanding that matters or is in the record?
Well, I'm not sure if it's in the record, but it is in the record that there is this other case out there. And I think you can take notice of the fact that the board has, in that case, relied on the fact that there was a post-election unfair labor practice as part of their assertion that there should be a bargaining order entered against Garten Trucking. And so that's really where this comes in.
So if in theory we were to rule your way, would that undermine the decision that has been made that your client engaged in improper election activity?
It wouldn't change anything about what they had done, whether they had committed those unfair labor practices or objectionable conduct, but it might go to the remedy. And what the typical remedy for the board is to order a new election. And one of the reasons that the general counsel has argued that's not appropriate here is that the employer allegedly engaged in this unfair labor practice subsequent to the election.
Okay.
So it does kind of tie back into that. I do think, Your Honor, that another thing to keep in mind here is that the First Amendment is an overlay on all of this. And so the cases, the Federalist case out of the Third Circuit, of course, Crown, Cork and Seal, you're familiar with, and Gissel, as the board cites, all talk about this balance of how do we protect speech and yet still allow enforcement of this act. And I think that what that really emphasizes in our facts is that it should be the board's burden to come in and put on the case that they didn't put on, which is that this was in fact a threat. And to fail to do that is to allow the board to essentially have this presumption of a threat in a context where it is pure speech, for sure, that we're trying to regulate here. And so I think that the totality of the circumstances show that it doesn't meet the true threat case. We did not mention in our brief, but I will go ahead and mention to you now for what it's worth, the Counterman versus Colorado case from 2023. And I think that, that's been mentioned in some interrogation contexts in other cases. But the point being that when we're talking about defamation or incitement or things that we're going to put in that box of not protected by the First Amendment, we want to have some standard that the person that wants to punish speech meets, and our argument, Your Honors, is that it was not met here.
All right, thank you. Hold on a minute.
No, sir.
Thank you, Your Honors.
Mr. Laro? Let me ask you something off the bat, Mr. Laro.
Of course, Your Honor.
When you look at this statement that we're talking about, you don't have a problem, as I gather, these worthless pieces of, with the statements that these worthless pieces of trash put in the paper, they handed out as pure horse shit for them to say they have anything to do with the raise for you is nothing but a lie. That language doesn't bother you, does it?
That's correct, Your Honor, or at least I should say.
What?
The board is not finding the language you just quoted was a violation.
But I mean, if it wasn't for this final sentence, you'd be okay with what was said.
Well, that's right in that there's nothing in the board's
Could you
decision.
speak up and put the microphone as close there?
Yes, Your Honor. Can you hear me now? Thank you, sorry. What you just said is correct. It's that last sentence that crosses the line from protected speech to a threat that is unlawful under Section 8A1. And substantial evidence, looking at both the statement itself, that blame the union statement, and the context, supports the board's finding. And as was discussed this morning,
So you're saying that the rest of it adds context to the last sentence?
it may add context, but the board made clear in the judge's analysis that the employer had a right to respond to the flyer and had no problem with what I call the employer's responsive, substantive rebuttal to the union's claim that it had an impact on wages. The
These
employer.
cases always raise a question in my mind about the tension between the National Labor Relations Act and the First Amendment, because democracy functions best and elections function best when you have the different sides to an election go at it with uninhibited speech. And certainly that's the way that these that most elections work. Now, here you have a question of labor organizing, but we have a statute that limits what people can say. And so how do we navigate what the board wants to do with its unfair labor practice jurisprudence and the presumption that in a democratic society, vigorous speech on both sides of the issue is not only permitted but encouraged, And I have always found this tension between the First Amendment and the union certification elections to be a difficult one for me. And how do you navigate it? I mean, if I were to look on one side of it, I could say, all right, this is a man who he owns a small company, and he's convinced that having a labor union in this company is gonna mean the end of his business as he knows it. And he may be right or he may be wrong. I don't know, but that's his view, that this is an existential issue for this man. And shouldn't we allow a good deal of sort of rough and tumble speech in those kinds of things? The company's fighting for its life as it sees it. Maybe wrong.
Right, I understand your question, Your Honor, and it is important to have that balance. And here's how that works, as I understand it. One good thing here is my opponent and I agree, when you look at page 16 of their brief, that the way the First Amendment is protected here is that under the First Amendment in Section 8C, you have a right to speak, to state your opinions, as you were just discussing with the company here, so long as you don't cross the line into a threat. But threats under Section 81 are not protected under the First Amendment or Section 8C. That's what my opponent agrees with on page 16 of their brief. That's what the Supreme Court said in Gissel, and that's the binding dispositive Supreme Court precedent on harmonizing the protections of the First Amendment with the prohibitions on threats under Section 8A1. And as the Supreme Court explained in Gissel, it's also working in the employee's right to associate, including through unions.
Counsel,
So here.
Go
I'm
ahead
sorry,
and
Your
finish
Honor,
your answer. I'll ask.
Oh,
want
I
you
just wanted to
finish.
say, you raise an important point. Can't the employer speak? And one might even say, aren't employees informed by having their employer speak? And the answer is, the board allowed the employer to speak here, and you said so. When you look at the statement, the claim that the union was lying when it said it should get credit for these raises, that wasn't a violation.
But he's
The
saying in effect to the employees, look, you're gonna do better without the union. And employers say that all the time in one way or another. And that's the heart of their case. And, you know, this speech was coarse, it was rough. And at the end, there's a link there that you wish were not there, and it was made too explicit by somebody who's probably not well-versed in labor law. But what he's saying in effect is, look, you're gonna do better without the union. This is a better path for you to take. And when I certainly understand your point of view, but what I'm wondering is whether we are sort of circumscribing the right of an employer to say to the employees, in terms of your economic well-being, we can take care of you, and you will do better without the union. And that's the burden of his case, is that you're gonna be better off without the union. He didn't, you know, it would have been much better if he'd said it less explicitly, but that's the point he's trying to get across. And I just worry about, at a certain point, the NLRA chilling employers' ability to make that basic point, and that is that your economic well-being lies in what you know and without the union. So it's troubled me a long time. So help me out.
Sure. Thank you, Your Honor. The first thing I want to say is, this decision which is narrow, leaves intact what you want, which is for the employer to be able to say, you're better off without a union, economically or otherwise. I think they're liars. They don't have any control over wages. All of that stuff, the employer said here, was fine. The problem with the last part is, when you get to the point, as the board reasonably found, that the statement here suggested to employees, reasonably viewing it, that they would face reprisal if the union continued to organize on their behalf.
But that's not, you said that, that's not what the ALJ said. The ALJ, and if that was the case, that would, be more reasonable. Maybe it's reasonable, but what the ALJ says at JA 110 is that any delay that the employees encountered, it's looking backwards. His language is past tense. And that the employees were paying a price for their union activities. As I look at the statement, the best case, it kind of follow up on Judge Wilkinson. I mean, there's a little concern that you're pulling out 1.5 lines out of 10 or so lines, most of which is okay. And doesn't that tell us that this really isn't the threat you're talking about? And then to the extent you're saying it is, the ALJ didn't say, hey, the message is in the future you'll face delays, or in the future you'll face reprisals. It's saying that any delays you did receive were caused by this, and there's nothing about anything ever happening in the way of delays or anything like that. So I don't know what to make of that, but I don't see how the ALJ's argument is matching up. Your brief and your argument seems to me to be interpreting the statement different than the ALJ decision did, and the board didn't do anything but affirm it. So that's all we got.
Well, a couple things, Your Honor. One is, I'm not sure how many lines it takes to constitute an unlawful threat. It can be done fairly quickly, and it was
Sure.
done here. That 1.5 lines was enough because it said, I blame the union for any raise delays here, any delays and raises. And the other thing I want to point out, because I think this gets to something I should clarify. My opponent's argument is, it'd be illogical to feel that you were threatened about delays and raises because in the company's view, employees know they had already timely received every raise they could get. But as we point out in our brief and the record shows, employees did not know that. In fact, if you look at page 16 of our brief, this is in the joint appendix at page 33 and 44, employees were asked, what do you know about the process of these raises being given? And one employee said, I don't know, nobody knows. The employees didn't know. The other employee witness, former employee who testified, said the same thing. Now, I understand the logic of my opponent's argument. If they could show employees knew there hadn't been a delay, they've got nothing to worry about, then maybe this post would seem nonsensical. But they didn't know that. So their argument is based on a fallacy, and I think another fallacy here is the timing. And Your Honor's addressed this morning. There's no law saying employees' rights dissipate as soon as the election is over. And here, after the election, what we had was a hotly contested representational issue where the union felt that the employer had engaged in illegal conduct, invalidating the election. It was litigating that issue, and it was continuing the campaign.
What kind of live testimony was there before the ALJ? And what kind of, what was the evidence before the board, and in what form did it come in?
Well, in this case, the substantial evidence supporting the board's view that this was an unlawful threat.
Okay, well, what informed the board's views? I mean,
Both.
give me a sense of the record or the,
Sure. We have the content of the statement itself. It's a blame the union statement, and similar statements have been held to be unlawful. We have the context. It's not like the election's over, so employees aren't making a choice or engaging in protected rights, or the union's not involved. They're continuing a campaign. And in that context, the company's owner, the one who has control over your wages if you're an employee, is telling you, I blame the union if your raises have been delayed. And it does suggest to a reasonable employee, which we always go
But
back to.
You're giving us your position. Judge Wilkinson asked, what's the evidence? And all it seems
No,
like you're
you're-
doing is telling us why the statement shows that threat. I get that argument, but I think he's saying, what did the ALJ have before it? Did it have witnesses who said this, that, and the other?
There were witnesses, and I was just explaining as to the assumption that this can't be a threat because raises had been timely provided. We had testimony that employees had received a raise before and after the campaign, but there was nothing saying, for example, that there was a regular schedule, so the employees could figure out for themselves, oh yeah, I've gotten what I've entitled to in a timely manner. Instead, there was evidence that the employees didn't know whether their raises had been timely paid. Maybe in the past, they were already delayed. Maybe they had already suffered.
Where does the
that.
board say where's the ALJ say all these things you're saying?
He says it was unlawful to blame the union for this post, and he says employees would reasonably worry that they had paid a price for the
Right.
union supporting them. And I think it's fair to say, you can always look on this record. What would a reasonable employee think? And they might also wonder, does this mean future raises might be delayed or disappear?
But
We have-
that's not what the ALJ said, correct? You could make that argument, and you might be right, but the ALJ didn't say there's a worry about how they would view future wages.
No,
The
I
A-
understand that.
Well,
One thing I need to do, Your Honor, and I didn't mean to cut you
Go
off there,
ahead.
but I think this is important. When my opponent makes an argument, I do need to respond on behalf of the agency when they have this view. It's an alternative view. As Your Honors pointed out, they have to show that the board's view is unreasonable, unsupported. No reasonable person could reach that view. But their view is, it can't be a threat that a wage raise had been delayed because they already knew they timely got it. But as I was explaining, they don't know that. And then in that view, you have to look at what a reasonable employee would think. Even if the board didn't expressly say, part of the potential coercion here is also, maybe I'll lose future wages, that is something you have to look at. I mean, that's just part of the context.
So
I
what
think
do
it's
you
enough-
do, we don't necessarily have them in this context. I mean, if that's what the ALJ's thinking, in other administrative contexts and in other,
Right.
look at review, we sometimes say, hey, you got to give us enough explanation so that we can understand something. And does our opinions in, say, immigration cases or sentencing cases that talk about, the requirements for some level of explanation apply here?
Your Honor, I see your point, and there is sufficient explanation here.
Is that a yes or a no? Does any of that law apply or inform us here?
You are looking at whether the board's decision is supported by substantial evidence. And I'm saying it is, because what the judge found is that employees would reasonably fear that wage raises had already been delayed. And you're right, that's what the board said, and that's enough to find a violation here because that view is supported. My opponent's alternative view that employees would just see this as hyperbole is not, and therefore the court should affirm. I do think you can look at the context, but to answer your question, even if we're just looking at the past, and the judge found employees would reasonably fear that their past raises, the raises they had already received,
I
had been
guess
delayed.
I think the point that Judge Quattlebaum raises is a very good one. And as to the past-future problem and the question that the ALJ was focused on the past, I suppose the response that you would make on that is that it is impossible to segment the past and the future, that if, that he's making a general statement about the fact that that wages are going to depend, that you have to look at this, and that he's saying really that, you would already have your wages, but that he's sending a shot across the bow And implicit in the statement is, yeah, and for purposes of the future, if you want your raises, you better stay clear of the union. And so that, the implicit threat of a future withholding of wages, the threat is implicit in this statement. And that the impact of the statement would not be lost on anyone when he's a part owner of the company, and has responsibility, at least partial responsibility for whether wages are forthcoming or not, that he's making a general statement about the fact that wages are going to be related to the presence or absence of this union.
I think that's right, Your Honor. What he said is reasonably viewed as a threat of reprisal for union activity. And that's unlawful under settled law. And I know one can debate, could the statement be viewed this way? Could the statement be viewed that way? But substantial evidence supports the board's reasonable view that employees would take this as threatening. And because it's a threat, it's not protected. In Gissel, the Supreme Court balanced the First Amendment.
Well, it's,
And the-
you know, it's troublesome because I think this fellow may have stepped over the line, but the board's awfully close to the line in depriving companies of the ability to say, economically, you folks are gonna be better off without a union. And that's an argument that the employees should be allowed to hear. And they should be able to weigh the benefits of a union and union membership, or the benefits of going without one. I mean, you want them to have full information.
Right.
And it may be correct, or it may not be, that the employees would be better off without a union. I don't know the answer to that. I don't, you know, that's a matter of speculation. But it's to the benefit of the employees to know that their lives may be better off without the union. And then the union can make the idea, no, you can make the point that your lives are gonna be better with the union. And just let the two sides have at it without handcuffing one side. That's, you know, that's my concern, and it's a real, when we climb out of the rarefied courtrooms, appellate courtrooms, and get down to what the gritty going on is in these union certification elections, it's pretty bare knuckle stuff. But you know, that's the way sometimes elections transpire in this country. There's nothing particularly pristine about it. And I just want to make sure that the employees are getting a full airing of each side of the argument. And so I understand you've got some very good points on your side. I understand that. I understand the standard of review. I understand what we're saying about coercion, and the long line of precedents that discourage the link between wage increases and union presence if the link is made too explicitly. But the other side has a point too, and their point is a very basic free speech point, and that is that we have the right to make our case in an unvarnished way. And this statement is as crude as it can be. But, you know, a lot of times that's the lingo in these elections. You yourself know that. And you just, I don't want to, you know, they have a point too, I mean, about not having these elections subject to judicial censorship. And so, you know, it would be nice if everybody recognized that there's a real problem here. I don't expect you to agree with me, and I don't expect this gentleman to agree with me.
I agree with what a lot of what you just said, Your Honor, and I know my time is up, but if I might just leave you with two thoughts. I agree. Employees are informed in free elections by free speech and being informed. We want them to be informed, not threatened. It's for the board in the first instance to draw that line. And here, as to everything you said that companies should be allowed to say about the benefits or detriments of unionization, the board gave the employer a lot of leeway here. Look at all the things in the statement that aren't an issue. Calling the union full of lies, horse, SHIT, useless idiots. And it can make its case that we, the company, give you raises, not the union. And so they're free to make their case, just not to cross the line to threaten employees, because that's not helpful in an election.
Okay,
Thank you.
hold on before you
Yes, sir.
sit down. Chief, do you have any questions that you'd like to ask this gentleman?
I did, but I forgot them. No, no, I'm just kidding. No, I'm just saying, I think that there is a balance. This scheme is by Congress in terms of, Congress wrote this. They felt this was needed for the people, and everybody knows there's an imbalance with power in terms of employers and employees. And the question is, Judge Quattlebaum, I think Judge Wilkinson addressed the point I was going to make in terms with Judge Quattlebaum. The reason why the ALJ was speaking in the past is because he was used in the past as an example. This is what it might look like if you have a future relationship. It had an impact on a delay of your getting wages. That's the coercive part. And in the hypo you gave Judge Wilkinson about the person who's in dire need, you could explain that, but you couldn't say, no matter how existential it is, that's the word you use, you can't say, well, if you unionize, I'm gonna have to close this plant. That clearly would be a violation, but it's the existential truth perhaps, or what the bottom line could be. But that's the balance that Congress reached in terms of regulatory scheme. And here, I think it's, and you don't have to show anybody was actually coerced. That's not required in terms of evidence. So I just don't see how it's not a reasonable conclusion that this is coercive as to what impact it may have on your wages. I think that's what Congress was meant to do. And I appreciate the angst we may have, but I think in terms of our role as a court, adjudicating it seems to be,
I think that's right, Your Honor. It's the balance struck by Congress as acknowledged authoritatively by the Supreme Court. So unless Your Honors have further questions, I
Marvin,
thank
do
you for your
have
time.
any more questions? All right, we
Thank you.
appreciate your argument.
Thank you.
And let's have, you have some rebuttal time, Mr. Tower. You know, these precedents and these standards of review, and that's a mountain of law to overlook. I mean,
I understand, Your Honor. I think that one thing that counsel said in response to a question, I believe, was that this was a narrow decision, and that's one place where we do disagree, because I think it is in trying to lump this case into those cases where the facts showed that an employer was talking
The problem
about.
with the statement is there's nothing that's particular, this last sentence, there's nothing that's especially subtle about it. It's, it's right up there. Listen, folks, if you wanna get raises in the future, steer clear of this. It doesn't leave much to guesswork.
Well, and Your Honor, I think our position is that the context of an election that took place over a year prior, the union issuing a statement that said, we somehow got you these raises that had just occurred, and the sort of, granted, hyperbolic response from the company management is to say that, you would have had your raises already, that might lead to an implication in some other context that there was some direct threat or true threat of future harm. But to lump this into those cases where the employer came in and said, if you unionize, we're going to treat you poorly, we're going to deny you raises, delay raises, when really what we have here is the NLRB turning the standard upside down. Counsel said that, first off, it's undisputed the undisputed evidence was that the employees got raises before and after the election, and that there were no delays. But the board is saying that's not good enough. You have to show now, apparently, that all employees knew that that was the case. There was only one witness that the general counsel called. There were not many witnesses in the case at all, but the point being that that standard can't possibly be the case. If the employer puts on undisputed evidence of the fact of what happened, which is that there were no delays, then that is part of the totality of the circumstances you can consider in deciding whether or not it was reasonable to construe this as a threat. And it's not just about the NLRA. It is the First Amendment, and the First Amendment is not subject to Congress's delegation to the agency of these decisions. And so you can decide that that First Amendment protection requires more. And then lastly, I would absolutely say we certainly believe we should win on the merits in this case, but it is true that the ALJ decision stamped by the board does not offer any of this explanation that is being offered in the argument today by counsel, and so that's another reason for sending it back.
All right, thank you.
Thank you, Your Honor.
Secretary, do you have the, yes, well, we thank you both. We'll come down and greet counsel, and then we'll move right into our final case. Olirri,
Good morning, Your Honor.
Mr. Farrell.
May it please the court, my name is Richard Farrell. I'm representing the appellant, Mr. Olirri, and his company. I'd like to first say this may be the most interesting courtroom I've ever been in so far as architecturally here throughout any circuit. Reminds me of the Da Vinci Library, but quite interesting. Judge Quattlebaum said a moment ago, in the prior case, there was something weird. Well, there's something weird in this case, too. First Protective, under their appraisal policy, had the right to deny the award. Instead of denying the award and simply proceeding, what we've spent is hundreds of thousands of dollars in legal fees, expended considerable district court resources and resources of this court, arguing whether or not Mr. Olirri and the two appraisers should be sued individually, and whether First Protective had a right to seek to vacate the award, which could only be through the State Arbitration Act, which they say is not applicable to this dispute. So those things are rather weird. Why they didn't simply deny the award that was granted. So, one of the first issues I want to address is the statement of the issues under the case caption today that appears on the calendar. Whether denial of a motion to dismiss based upon arbitral immunity is final and appealable under 28 U.S.C. 1291. That statement of the issues seems to me, when I reviewed it, when I first got the calendar, appears to state that Mr. Olirri has arbitral immunity. And whether or not, if that's the case, he has an appellate right here. if Mr. Olirri, in fact, as stated here, has arbitral immunity, then that immunity is judicial immunity and is absolute.
Well, you don't, I mean, I'm not, you can argue however you want, but if your reliance is on the way our calendars stated the issues rather than the record and decisions, that's probably not your best tactic. I mean, I think the issue is, does someone who does an appraisal or does someone who serves as a referee get the same, you know, protections as an arbitrator? Are those the same, or either under the text or functionally? And, you know, so anyway, you can argue however you want, but I'm not sure our calendar is precedent for it.
I agree with Your Honor. I just wanted to make sure that that issue was addressed, if in fact that was on the mind of any party, any of the judges here on the panel. Moving to the appraisal process, that was designed by First Protective unilaterally. As I said a moment ago, they had the right to deny that they simply overlooked, and in fact misrepresents to the court in their briefs and in the complaint, because they never refer to the right to deny. They leave that off of their quotation of the part of the policy in question. With regard to the functionality issue, which forms the basis of the right to appeal, the functionality or the function performed by Mr. Olirri is admitted to resolve the
The
dispute.
opponents are saying you never raised the functionality point before the district court.
I don't think that's accurate, Your Honor. The functionality claim was raised before the court, and it was disposed of with regard to the analysis of Delenko. Delenko states and incorporates specifically in the common law the functionality test, which represents exactly what Mr. Olirri was performing here to resolve the dispute. The court disposes of Delenko saying it's inapposite to the claims in the case. The Delenko case was directly related and controlling of common law in North Carolina, because that's the only case, and the latest case in the line analyzed by the district court, the only case that reviews the functionality test and simply denies it as being inapposite. It is not inapposite. There's no dispute that Mr. Olirri resolved the dispute exactly the way he was instructed to or required to under the terms of First Protective's policy. He
What do you
performed
do-
that full function, undisputedly.
Counsel, what do you do with PHC versus North Carolina Farm Bureau Mutual Insurance Company? It seems to be an appraisal process very similar to this. And it seems to pretty explicitly say that none of the persons determining the amount of the loss, which is what I understand to be the subject of what's done here, are referred to as arbitrators, nor are the provisions of the Uniform Arbitration Act even obliquely mentioned. Seems like that's real close to our case. Am I missing something about how it compares?
I believe so, Your Honor.
Okay. Please tell me.
PHC was decided before Delenko.
Okay.
There's no claim that functionality was ever raised in PHC.
But aren't they talking, they may not be using the word functionality, fair enough, but it seems like they're talking about it in functionality-related terms. What are they actually doing? And it seems like what they're saying there is if you're determining the amount of a loss, that's one thing. It's not the same function as an arbitrator who's resolving an overall dispute.
And in PHC, they never reviewed the functionality test. The
Okay.
functionality test of Burns versus Reed, which states both in the majority opinion and in the concurring opinion what the functionality test is. Never considered in PHC. Delenko was determined after PHC, reviews expressly or explicitly the functionality test, and incorporates the terms that says that a person performing the function of resolving a dispute is protected pursuant to immunity.
And your position has to be, and sounds like it is, that you think that language encompasses even the, not the overall the dispute as to who wins or loses, but the financial or amount of the loss, that's enough? That's your argument, right?
Well, I'll say yes, further stating in response to that, Olirri did determine the amount. He performed that function. There's nothing that I could determine existed in PHC that reviewed the function, okay? Nor
I understand that
analyzed the
point, yeah.
function. Delenko did. Delenko incorporated Burns. I would say with Burns, in the majority opinion, goes back historically into where immunity, judicial absolute immunity, attaches in any judicial process. There's no limitation in Burns nor in Delenko with regard to the terminology arbitration agreement, arbitrator, umpire, referee. It's the function alone. If we don't stay away from, if we consider these terminology issues, then we are simply saying that any commercial entity and the entire insurance industry can simply say, you're an umpire, not an arbitrator, okay? That would wholly undermine the legitimacy of the whole process that First Protective says is credible. There's no credibility to a process in which the arbitrator or the umpire or the person making the function of fulfilling the obligation under First Protective's own policy, there's no protection that they provide. We would get to exactly, well, I don't want to say exactly, a similar argument of, is each member here subject to impeachment? Okay, what would that do? That would be wholly undermining the judicial process. Olirri did not get involved. No one would get involved in any of these functional processes if they could be individually sued. These gentlemen, the appraiser and the appraiser for First Protective, as well as Olirri, are essentially bankrupt now. They've been involved in hundreds of hours, thousands of hours of legal representation. Is that the policy that was put into place by First Protective that would not be credible at all and that would be approved by this court? As far as I know, this is actually an issue of first impression. Are people serving the function of dispute resolution immune or aren't they? People who are out there who are potential
Sometimes things are
umpires.
matters of first impression because no other court has seemed to adopt your position.
I'm not aware of it ever being considered. That's why I'm
Well,
saying it's
there-
a matter of first impression.
The reason, the reasons it hasn't been considered, and that is because no one has ever considered individuals in the situation as your client to be arbitrators, and that's just for starters. They seem to be, as far as I can tell, more akin to insurance adjusters than they are to arbitrators, and the fact that they determine the amount of loss doesn't mean that they're necessarily arbitrators. They haven't gone through the arbitrator. Most of them at least go through a very formal process, and it's quite an intensive vetting process. And then you pile on top of that is, I think it's reluctant to expand the collateral order doctrine too much because we're going to be nibbled to death by piecemeal appeals. And in this case, if I'm going to vote to expand the collateral order doctrine to this, I would expect the North Carolina courts to tell me that hey, these folks are full-fledged arbitrators and they have arbitral immunity under North Carolina law, and it's an immunity from suit, as well as an immunity from liability, and I don't see any of that.
And I would say,
I don't see that coming out of North Carolina, okay?
well, it appears that the Delenco court decided that anyone serving the function of resolving a private dispute as a private citizen is entitled to that immunity. And that's exactly what Burns versus Reed said. So either we adopt the opinion of Burns versus Reed, which says what Olirri claims, and which Delenco adopts expressly in its opinion as the common law of North Carolina, or we don't. That's obviously the decision of this panel.
But the point is, there are all sorts of dispute adjudicators that aren't full-scale arbitrators. The insurance adjusters are one, but, you know, whenever you make a claim, let's say, to health insurance, and you want reimbursement under the health insurance policy or something, well, some individual somewhere is determining the amount of loss. But that doesn't make them an arbitrator. They're dispute resolvers throughout our society. They're in many companies. They're all over the place. And if we have the idea that they're all many arbitrators, and that every adjustment that they make that if they're granted, denied immunity, arbitral immunity for one thing or another, I just think we're gonna be nibbled to death by these interlocutory appeals. And there's something to be said for leaving matters in the district court until it's all wrapped up. And this seems to erode that.
May I respond, Your Honor? I know I'm pretty close to out of time.
Would you like to respond in your rebuttal, or would you like to respond right now?
So I'd like to respond right now because it's Your Honor's comment to me that I'm responding to rather than opposing counsel.
Go ahead.
I understand your leeriness. Primarily what you're alluding to is internal administrative decisions, not decisions that that occur pursuant to a prescribed dispute resolution process. This is a decision made by an individual that has been appointed as an individual to resolve the dispute. I believe what Your Honor is referring to are internal administrative decisions that don't go by a dispute resolution process that was established by the insurance company.
You're leading us down a trail where we're gonna say, well, this person's an arbitrator, that person's not, this person's an arbitrator, that person is not. And then, you know, that's gonna become a point of contention in collateral order doctrine appeals, and it makes sense to stay in some lanes and hold that somebody where North Carolina law says only there's an immunity from liability and not from suit, and where North Carolina law has not signaled to us that this is even an arbitrator. I don't know why we'd be sort of launching out on our own, but you've got some rebuttal time, and you can make your points at that point. And
Thank you.
if my colleagues have questions for you now, I'm happy to see Marvin.
Thank you, Your Honors.
Thank you.
May it please the court, my name is Mihaela Kabulea, and I represent First Protective Insurance Company. Your Honor, respectfully, this court does not have jurisdiction under the collateral order doctrine to review the district court's denial of the arbitral immunity under the North Carolina Arbitration Act to the appellants in this case. And I want to point out, and I want to walk the court, which I'm sure the court is aware of, that all the steps that are required to be met in order for an interlocutory order to be reviewable on immediately under the collateral order doctrine. And the first one and the second one are kind of not at issue here because they require that the order conclusively determine the issue, which that has happened here, that the order resolves an important issue completely separate from the merits. We agree that that's separate from the merits, but the third prong that has to be met is the problem here, and that is that the order is effectively unreviewable later on in the case from the final judgment. And here is the main problem with this particular order and with the appellant's argument, because although neither the Supreme Court nor this court have addressed the issue whether arbitral immunity, an order denying arbitral immunity is reviewable immediately, further cases that have narrowed even more the collateral doctrine, collateral order doctrine after the Cohen decision indicate that this would not qualify as an immediately appealable.
What if it was an arbitrator, a plain and simple arbitrator?
Even-
That's all right.
Sorry.
No question about it like there is here. If a plain and simple arbitrator is saying, under North Carolina law, statute and case law, I have absolute immunity, not liability, not immunity from liability, but immunity from suit, would we have jurisdiction?
Your Honor, I still think that the court would not have jurisdiction because it's not what the arbitrator alleges, but it's what the statute supports. And going to the very language of the Arbitration Act, I want to walk the court through the steps and through the language of the act that clearly provides for immunity from civil liability solely and not from, and I want to direct the court's attention to subsection, I have 1-56914D of the act that, for example, addresses the immunity of an arbitrator pertaining to discovery. So the act specifically says that in judicial or administrative or similar proceeding, an arbitrator is not competent to testify and shall not be required to produce records and so forth, the same way as a judge of this court and this state would not be required to do so, unless, and here is an exception that we believe applies even here, unless this subsection shall not apply to a hearing on a motion to vacate an award under subsection 1-56923 if the movement makes a prima facie showing that a ground for vacating the award exists. This is exactly what happened here, Your Honor. And my opponent keeps claiming that we had the option to deny the award. We had the option to deny coverage under the policy after the award was issued. We did not pay the award. We sought a declaratory judgment action to vacate that award. So that's the proceeding. And the allegations in the complaint make a prima facie case that there is a problem with the appraisal award, like under the Arbitration Act here. Because we alleged in the complaint that the Olirri and the Olirri appellants, they were not impartial. Mr. Olirri signed that document that says, I am going to be strictly impartial here. And he, in fact, was acting as a consultant on a different claim by the same insured, with collaborating with the insured's own appraiser and public adjuster. So that's the ultimate allegation of lack of impartiality and bias and improper conduct, because nobody disclosed that. And ultimately, he came back with an award that was over $1 million, that was 4 times the amount initially submitted by the insured. So these allegations meet that kind of requirement even under the Arbitration Act. And then the arbitration.
So if I could interrupt you, counsel, what if there was a suit against a North Carolina judge and they sought to appeal, saying they were absolutely immune? Would we have jurisdiction to hear that?
Yes, Your Honor, that is very different. And I think if Your Honor looks at the language of the opinion in Mitchell versus Forsyth, and we cited to that in our motion to dismiss, the court in that case points out to the fact that judges have absolute immunity. And that means absolute immunity, you are immune from suit. But the court further notes that there's a very different rationale behind the absolute immunity granted to judges as opposed to the attorney general, which was at issue in that particular case. Because the judicial process is subject to certain procedural safeguards. A judge cannot abuse that immunity because there are procedural rules that the judge must abide for. There are appellate options and avenues for the court to do. So that's why it's a completely different process. And even arbitrators, they are quasi-judicial proceedings. The rules of evidence apply. Attorneys come and present evidence on behalf of their clients. In an appraisal process, it's two appraisers representing the two parties.
Yeah, I get your argument I understand your argument that this, Mr. Olirri's not an appraiser, not an arbitrator.
Right.
So, I appreciate that. I wonder if you're right about the hypothetical that an arbitrator could not, appeal saying they're have absolute immunity. I understand your position. So-
And I do have, if Your Honor allows me to
Yeah.
answer, to finish that answer, I have other provisions in the Arbitration Act, North Carolina Arbitration Act, that support our contention that an arbitrator does not have absolute immunity because subsection A of
Do you have a North Carolina state law case that says that?
No, but it's the language of the statute
I
that we
got
are going.
You're welcome to repeat that. I read those arguments in the briefs,
Oh,
but
okay,
so I appreciate them I understand, but you're welcome to make the point. I'm not trying to discourage you.
The statute says that they're immune from civil liability, and then they provide for attorney's fees at the end of the case for an arbitrator if the arbitrator is found to be immune from civil liability. So that's where our argument comes from, basically, and that's why we are arguing that. In addition, Your Honors, what happened in this case indicates that the Olirri appellants never even raised the immunity from suit until they responded to First Protective's motion to dismiss the appeal for lack of jurisdiction. Nowhere did they move to dismiss. They didn't move to dismiss the complaint saying we are immune from suit. They didn't file in their answer and affirmative defenses. They didn't reference immunity whatsoever, not even arbitral immunity or from civil liability. They didn't reference immunity from suit in their answer and affirmative defenses either. It took them a year and a month, to file their motion for judgment on the pleadings and argue that they are immune from civil liability. So the first time the word comes up is in their memorandum in support of their motion. It's document entry number 61, and that's where they reference immunity from civil liability. And then even on appeal, in their opening brief, they never mentioned that they are immune from lawsuit. The words are immunity, they are immune under the Arbitration Act, and then immune from the claims by First Protective. So those are the arguments. In that respect, we would practically argue that they waived even that immunity from suit because they engaged in litigation for over a year. They produced some discovery, quite extensive in response to discovery requests. So
You raised that argument in your brief.
Sorry?
I said you made that argument in your brief.
I believe we made that argument in the motion to dismiss, Your Honor, because in the brief, we
Right.
just adopted the,
Right, right.
That-
Are there any arguments that you have to make that you feel that you didn't make in your brief?
I just want to point out, and probably we made, in the brief, we made all the arguments, but I just wanted to point out briefly on the Delanco opinion. That does not address an appraisal proceeding, and that was issued before the legislature, North Carolina legislature, has adopted the act in 2000, when the act became effective in 2004. And the court even said in that opinion in a footnote that that's why the court looked at the functionality test. And in addition, in that case, the parties they agreed to submit their dispute to an arbitrator. And it was an arbitration proceeding, it wasn't,
Is there anything further, counsel?
no, Your Honor, unless you have more questions.
Let me, thank you very much.
Thank you very much.
Mr. Farrell?
Thank you, Your Honor. So far as the citation by opposing counsel of Section 14D regarding Mr. Olirri being required to testify, or any person providing a function of dispute resolution being required to testify under the Act, he can only be required to testify with regard to a motion to vacate. It has no effect on his immunity. He remains completely immune pursuant to judicial immunity. Even if there is some claim that he may have acted out of the course of what he was required to do.
That's if he's an arbitrator.
I don't believe that the functionality test has anything to do with terminology. If it had to do with
But,
terminology,
counsel, you're referring to the North Carolina Arbitration Act.
I am. And what I'm saying is that North Carolina common law is pursuant to Delanco, a party providing the function of the resolution of dispute, which First Protective defined as the role of Mr. Olirri in the process, in their own contract. If
You know,
he's,
that functionality test, counsel, that you're suggesting is one of the most litigious I've heard. We could be debating forever whether somebody functioned in this sense or whether somebody functioned in that sense, and what are the different criteria for the functionality as an arbitrator, and when is it met and when it's not, and when we depart from the relatively clear contours of the collateral doctrine into the vague land of functionality tests. There's enough litigiousness around the collateral order doctrine as it is, and to add a functionality test to the existing litigiousness just strikes me as a very bad step.
here, the issue is undisputed. The contract says expressly, Mr. Olirri was responsible for resolving the dispute. That is the function. The function is defined by Burns versus Reed by the Supreme Court and adopted by Delanco. The court is obviously free to ignore that standard. However, our position is it is defined in their own contract. There's no factual definition that the court has to impose. He was obligated to resolve the dispute. Beyond that, unless he,
But
unless.
there are all sorts of contracts that have dispute resolution procedures, and that have all sorts of mechanisms set up for a remedial phase, but that doesn't mean that they've established an arbitrator or the process for arbitration.
This one did. This contract does.
Well,
The-
but there are many contracts that have a provision as to how amounts of loss will be negotiated or what have you. But that doesn't go around establishing little arbitrators here and there.
Well,
That's the problem.
well, Mr. Olirri was not a little arbitrator. He was responsible for determining the dispute. Did First Protective ever say to him that he could be individually sued? No. Did they have the right to deny the award? Yes. Why did they not deny the award? For one reason. There was one reason and one reason alone. Vexatiousness and vindictiveness. They didn't have to sue any of these people. They took their process to resolve a dispute. That process they contractually provided
No, you
for,
can raise
and they
that-
turned
you
it
can-
into a
you-
weapon.
You can raise that on appeal. You don't have to raise that in a collateral order appeal. You can raise that when you bring your regular appeal.
Your Honor knows that the case law is replete with decisions that say that immunity is of the utmost importance to the process of dispute resolution. You
Immunity-
can't wait on that.
Counsel, that's part of the point. You know, there are immunities and there are immunities, and one of the points that the opposing side makes is that there are differences between immunities from liability and immunities from suit. And the immunity that you're talking about is an immunity from liability such as it is, but that can be raised in the normal course of litigation. It doesn't have to come up here. It can be raised in the normal course of a lawsuit, and then if you're dissatisfied with it, you can include that among the claims you bring on appeal. Everything doesn't, every disappointment that a litigator encounters in the course of a lawsuit doesn't result in an interlocutory appeal. We have to, I do not want to be, this court, to be devoured by piecemeal appeals.
It has to do with immunity, which is paramount to the process of an honest judicial procedure. If the court doesn't wish to enforce that, which would be consistent, I submit to this court's prior historic opinions with regard to immunity being a most important issue for the judicial process required to be determined at the outset, then that's a decision that needs to be made at that end of the discussion,
All right.
not by me.
All right, thank you, sir.
Thank you, Your Honor.
We appreciate it. We will adjourn court and head down and greet counsel, and I want to thank our courtroom deputy, Ms. Hancock. You did a very fine job. Thank you so much.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.